Welcome, everybody. I'm happy to have you here. Maybe I should talk in Russian, but we leave that for the moment. We stick to English. Happy to have you here. We are very much honored to have a colleague from originally Russia, but now Kazakhstan with us, Nikita Lyutov, who is a professor in Kazakhstan, as I said, as the Nazarbayev University in Kazakhstan, an associate professor for 3 years by now. He is doing international labor law. So today's law after lunch lecture is in the general interest of the Institute of Economic Law that I have the honor to represent here. As you all know, we have the Master Studies program on economic law, and part of that is obviously labor law. It's an important aspect, and I'm not a specialist in it, even though I did publish on international labor law. Part of it is, and increasingly important, is European for us as members of the European Union, but also international labor law, obviously. And therefore, it's great to have a presentation today within our Law After Lunch series on international labor law in a broader sense, first, and secondly, of course, on the Eurasian Economic Union, which is there for many years already, but not that much realized and recognized within the European Union for maybe political reasons on the one side, maybe also because the Eurasian Economic Union is, let's say, not as smoothly operating by now as the European Union is, but also maybe we are looking in different geographical directions sometimes, and too much if we are interested in comparative and European international law. It's a very important development, of course, on the Eurasian Economic Union. And we are happy to have a specialist with us. Nikita was trained as a lawyer and worked for many years and long time in Moscow. You were born in the Soviet Union, then of course it was Russia. You worked in Moscow, both in practical terms and in academic terms. You received your 2 PhDs, the doctor and the habilitation, in Moscow, and then later on, 3 years ago, as I said, you moved to Kazakhstan. You are teaching broadly on labor law, you publish broadly on labor law, and you advised in all different kind of functions on those issues. So we really have a specialist with us, not only in general on labor law, but with regard to the region that is of so much interest for us. Just for everybody to remind us, we have very close ties to Caucasus and Central Asia, very important countries in that region for us as a Martin Luther University, for the Institute of Economic Law. We had many exchange programs. I myself was teaching in Kazakhstan. We had summer schools, several in Azerbaijan. We have just last week we had a presentation of a colleague from Georgia here with us. So we have, I forgot, about 10 or something like that, students from the regions with us this semester, sitting in my and other classes. And therefore, this is a very close cooperation, and Central Asia is, of course, of interest for us in a geopolitical sense, because it is becoming increasingly in the center of economic activities between Europe and Asia, namely China. It is right on the new Silk Road that, as we all know, has been proclaimed in Almaty in Kazakhstan. And therefore, this is really much of interest, and it's good for us to know a little more about the region and the law, of course, in this regard, and that will be presented by Nikita to us.
Thank you very much, Professor. Dear colleagues, Well, thank you for presentation, and I'm very glad to be here. First of all, a little bit more about me before talking about the theme, in order to understand the area which I'm specializing in. I'm working in comparative and international labor law, and from time to time I'm consulting International Labor Organization, the ILO, on the compliance of the post-Soviet countries to the international labor standards, and we're making research projects in this issue in order to find the incompliances and show to offer some recommendations for the governments of the states to be in line with the standards of the ILO. And today's theme regarding the format, I'm encouraging everyone to interfere at any moment, so please let me know that you want to either ask something or offer some suggestion or start debating, because probably there are not so many of us, and I may be talking about some things which may be close to something which is interesting to you, but not specifically. So you may offer me to shift a little bit to something which may be more specific to your personal interest, and I may give you some insights or whatever. And I will be very happy if we will start the discussion. And I'm not programmed to cover all the topics which I was planning to cover. So it will be okay if I will shift somehow, and it will be an open discussion. Still, I left some time for discussion, but again, I'm very open to start it right in the middle of my report. This would be absolutely okay. So the theme is Eurasian Economic Union states labor law in comparison with the European integration project. Obviously, I will not be talking about the EU. You know EU law much better than I do. But I will show you some comparison, because by the very name of this EAEU, Eurasian Economic Union, you may guess that the idea of the union itself was borrowed from the European Union, but obviously there are some points of comparison, but this is something completely different. When we talk about the integration projects in the territory of the former Soviet Union, we should start from the earliest and still living project integration organization, which is called Commonwealth of Independent States, CIS, which is some kind of mild divorce of the former Soviet republics. To a certain extent, it may be compared with British Commonwealth. So the very name independent states shows that former Soviet republics are currently independent, but they were very tightly, it was the single country with very tight economic and structural and logistical chains, so the idea was not to completely destroy them, and the CIS project is about this. And now it is even difficult to say what countries are there in CIS. For example, if we talk about Ukraine, it declared that it is no longer in the CIS, but in the same time the secretary of this organization made a statement that the procedure of this exiting from CIS is not formally complete, something like this, and other post-Soviet states have the status of observers. So if we talk about the labor migration, probably what unites these countries is visa-free travel for the citizens of this countries to each other. Some post-Soviet countries were never there, as Baltic states or as Turkmenistan, which is very close states, but most of the post-Soviet republics are somehow. And this term SNG, CIS, in post-Soviet discourse is often used as a kind of regional synonym to describe it. It not necessarily refers to actual formal state. It may be the meaning of the post-Soviet states. The countries of CIS or SNG is kind of informal mentioning of the post-Soviet status of these countries. Later in the year 2000, other integration, already the integration after this disintegration project, organization was established, Eurasian Economic Community, Eurasian, the Russian abbreviation, which, well, you may compare it with European Economic Community, and after Eurasian Economic Community you see Eurasian Economic Union, so you already see the similarity with the steps of the European integration, but well, the links between the states are much weaker, and what was important for this Eurasian project is that the countries which were there, Belarus, Kazakhstan, Kyrgyzstan, Russia, and Tajikistan, intended to create the common economic area, which, well, didn't work out, not even perfectly, it just didn't work out. And later in 2015, this Eurasian Economic Community was closed, and instead of this, another union, closer one, for initially 4 and then for 5 states, Eurasian Economic Union was founded, and currently it includes Armenia, Belarus, Russia, Kyrgyzstan and Kazakhstan, 5 countries, 2 of them East European, 3 of them Central Asian, and what unites them is that, well, I will use the slide, we'll start comparing it with labor law integration first. If we look at European Union labor law, we see that, and try to compare it with this EA-EU project, we may see that some points of integration come from not just different, but to a certain extent opposite dimension. If we talk about the European Union, then we have the completely different legal traditions of the member states, completely different systems of labor law. Some of them, before Brexit, for common law systems, based on different principles, different legal traditions, and they are tied within European Union by some fragmentary EU directive on specific issues like working time, transfer of undertaking, workers' participation, etc. There are manuals on European Union labor law, but this field cannot be compared to the national labor law of each member state, because national labor law includes all regulation, all institutes of labor law, while the union labor law contains only the issues which are covered by the directives and supranational regulation. Eurasian Economic Union comes from the situation when the countries of this union had initially identical labor law. Formally, they were labor codes, different labor codes for each of 15 Soviet republics, but they were not similar. They were almost identical. They were the last versions of Soviet labor codes were adopted in 1972 in each Soviet republic. Only in one post-Soviet countries this Soviet labor code is still in force. This is Ukraine. It is completely redone, obviously. It is modernized severely. And there is Soviet labor code also in the European Union. Poland has Soviet time labor code up to now. It is still in force. But socialist countries didn't have this identical legislation like the Soviet Union republics. They were obviously made to rather similar model based on comparable principles, but when we talk about the republics, they were based on the act which was called the Basics of Soviet Legislation in different branches, and there were basics of labor legislation adopted in 1971, after which all the labor code of the republics were adopted, and the differences were some national holidays and some minor issues reflecting national traditions, and that's it. All other things were identical. And since this time, since the Soviet Union ceased existing, the labor legislation of the countries was modified, but the trends in the modification of the labor legislation, as the legislation in general, was very much influenced by rather isolated Soviet legal doctrine. Partly, and I think to significant extent, it is the issue of language, because in the Soviet Union, people didn't speak foreign languages. They were intentionally not taught very well. When you were studying in the normal, not specialized school, you couldn't be fluent in any foreign language. And therefore, still the communication is rather isolated, and the countries are looking, post-Soviet countries are looking to each other up to now, borrowing from each other. Many of them are looking to Russian legal doctrine, because the doctrinal development in the biggest country was stronger, and but still, when we talk about the legislation, it is not necessarily borrowing something from Russia, because Russia is also borrowing some norms from other countries, and this is about the differences very broadly. I will talk about the specifics of the member states a little bit later. And unlike European Union, Eurasian Economic Union doesn't up to now claim to create some unified labor legislation. There are discussions about this, but mainly at academic level. On political level, there is only the joint economic area, and from point of view of labor law, what is very important is that Eurasian Economic Union establishes the free movement of labor for 5 countries, and I'm the beneficiary of this system, because when the war started, I could move to Kazakhstan, and I didn't need any permission to work in Kazakhstan. Once I concluded employment contract with my university, where I'm currently working, they addressed to migration service, and because of I could enter the country without visa, and but as the tourist. But once I concluded employment contract, they applied for permission for residence, which I received automatically because I have the employment contract. So it's not my obligation to get the visa for employment. They are informing that I'm employed, and therefore I receive this status automatically. There are exclusions from these rules. Not all the professions are open for other states of the Eurasian Economic Union, but general principle is this. So now about the similarities of the labor law of at least these 5 member states of the Eurasian Economic Union. It sounds strange that we are in 2025. It is more than 30 years after the dissolution of Soviet Union, but in labor law, Soviet system of industrial relations is still very deeply rooted, despite the fact that often the trade unions, the employees, the employers are even not aware about this. But the very understanding of the institutions and the relations between them is very much rooted in the Soviet structure of the industrial relations and employment relations. The Central European countries, which are currently members of the European Union, have passed the transition from planned to market economy in other way compared to the post-Soviet countries. These post-socialist countries of the European Union have passed, if we talk about the employment, through the period of dismantling the Soviet socialist enterprises, which were not economically affected, and in 1990s they have faced a shocking wave of unemployment, and many of these Soviet uncompetitive enterprises were closed. When the attempts to do something like this were tried in 1990s in the post-Soviet countries, specifically in Russia and in other countries, the countries have faced the wave of social unrest, the protests. It is very difficult to imagine now, but in Russia of 1990s, thousands of strikes were registered every year. To compare with current situation, it can be 0 strikes for this year, 1 strike, official strike. Strikes are constitutional right in all Eurasian Economic Union states. But if you look at the official statistics, you would see that in current situation, it may be 0 or 1 strike or 2 strikes. So in practice, they're prohibited, but formally, it is the constitutional right. But in 1990s, the countries have faced this social unrest, the protest of the people who were losing the work, and it was some kind of social contract between the state, the employers, and the workers, that workers were not psychologically ready to lose the job because they were brought up in the system where there is absolute job security. You may not receive a good salary, or you may not live in very good conditions, but you have a secure future for your lifetime. You know that you work until the pension age, then you receive your pension, and your life career is predictable and secure. And this has fallen apart. It was a shock for millions of people. And in order to deal with the protests and the shock, the government and the employers were trying to avoid the dissolution of these incompetitive businesses. They were trying to minimize collective redundancies, and instead of this, they were offering, well, first of all, in 1990s, there were years when the wages were paid with big delays. The amount of wages was just symbolic. You couldn't survive on this, but still you had the status that you are working in this factory or you are the researcher in this institute. Well, your salary may be $15 per month, but you are a researcher, you still have the status and some kind of idea that, well, this is something. And the labor market was somehow adapting to this, and currently there is a very low level of unemployment in most of the countries of the region, and still relatively low level of wages. Minimum wages, average wages, when we compare the GDP, gross domestic product of the country per capita, with the average wage in this country, and we will compare these numbers with the countries of the European Union, which are comparable by economic development, we will see that in the comparable countries, from the point of view of economic development, the wages in Eurasian Union countries would be few times lower, but unemployment is also very limited. And another feature is that the trade unions which were existing in the Soviet time in European Union countries, they were usually closed. And instead of this, for example, in Baltic countries, the trade unions were, Soviet trade unions, were considered to be not the real trade unions. What were the Soviet trade unions? There was the Lenin's or Zinoviev, another Bolshevik who was later arrested and shot by Stalin, phrase, it is difficult to trace the authorship, that trade unions are transmission gear from the Communist Party to masses. It's not, well, market economy representatives of workers. They were not formally considered as the part of state, but they were some kind of intermediary between the state and the workers. There was no right to strike in the socialist countries, neither outside of the Soviet Union nor inside the Soviet Union. Here in former GDR there was no right to strike either. And there was almost 100% membership in trade unions. And the activity of the trade union was still some kind of protection of workers, but it was a different type of protection. If, for example, company director was abusing his status or her status and was not providing something for workers, the strategy of Soviet trade union was the economy was vertical. It was all controlled from the center, from the Ministry of Planning. It was called Gosplan in all socialist states, and they could make a complaint against this company director to the higher instance in order for this company director to be penalized. So it was obviously some kind of protection, but not the representation in the real collective bargaining. For example, about the wages. You couldn't bargain about the wage because, or about anything. According to Soviet labor law doctrine, the meaning of the employment contract was that it is the legal fact. Socialist law doctrine operates with the idea of legal facts, is some events or actions which lead to the change in the legal status. So this is the legal fact that fixates start of your employment. That's it. Because you were not agreeing about the amount of your wage, the length of your work, or whatever, because it was if you have specific specialization, profession, it was fixated in your contract, and you were receiving your wage according to centrally approved network of wages, depending on your qualification, starting from tariff 1, ending on tariff 14 or 18, depending on whether you are industrial worker or you are executive specialist. And there is no space here for wage bargaining, because trade unions didn't have the right even to bargain about the wage in such situation. They could adjust some small, like German works councils. They could adjust specific arrangements on local level, and again, comparable with German Betriebsraten, they could put a veto on the decision of the company director on specific issues. So the system was completely different. And in European Union countries, these Soviet trade unions were disbanded, while in the post-Soviet countries, they stayed. They were named independent trade union federations. For example, leading modern trade union federation of Russia is the Federation of Independent Trade Unions of Russia. Kazakhstani Trade Union Federation doesn't contain this notion of independent. Neither of them are independent from employers or the state. They are still part of unofficial part of the state machine. There are no specific legal mechanisms providing for independence of trade unions from the employers. There are only slogans in the legislation that trade unions are independent, like statements. But for example, in Kazakhstan, you may be company director and in the same time the leader of the trade union. The law doesn't prohibit it. You may establish the trade union, which would unite the executive workers. You may establish the bylaws of this trade union, saying that, well, the founding members are the deciding members of the trade union, and then we will invite, obviously, compulsory trade unionism is prohibited. There is a negative right for association, but you can kindly invite all workers to HR department and say, well, would you kindly sign the letter that you are joining our good trade union? And well, there is another bad trade union in our company, which are coming into conflict with our dear leader of the company. You understand that those guys are bad. We don't suggest you to, we are not threatening you, obviously not. Well, no threats. Sign here, enter this good trade union, don't enter that trade union. Just a suggestion, mild suggestion. And well, can HR offer this? Well, he or she can, and there are no, if there are no open threats, which you can, and there is no need for open threats. And the trade unions were, in most of the countries, were divided to so-called old trade unions tracing back to the Soviet with this mentality. Sometimes they are, and very often they are thinking about the interests of workers. They still trust in what they are doing, but their mentality is to protect workers in this Soviet-style system. And they, for us to understand the feeling of this system, again, sorry for speaking about the Soviet Union so long, but the ideas and the spirit of this is very much rooted in the system. If you would ask the person on the street, for example, in Kazakhstan or in Belarus or in Russia, what are the associations for you with the trade union, they would say do something like, these are the old guys which may award some veteran of labor for good work, something like this. Can you imagine the trade union in Western country awarding the good worker for good work? Because this is the veteran of labor. And for them this is normal because the mentality is there. And there are so-called new trade unions or alternative trade unions. They were started being founded also already. They are not that new. The first of them were created in the end of, back in the Soviet Union, in the last years of the Soviet Union, in the end of 1980s, in the mining regions, for example, in Western Siberia, in Urals, where the miners were going to strikes. And those alternative trade unions are more conflictual. They are bargaining about wages. They are inefficient. They may be pretty efficient. They are more aggressive in the relations with the employees, and they are by far lower in terms of membership. They are always the minority unions. And it is explainable because if you're a worker and you are not, you want to retain your employment, right? You don't want to get into quarrel with the employer. Unless you are ready to lose your job because you cannot tolerate the terrible treatment of yourself, you would avoid the conflicts with management. And therefore, if you are suggested to join this good union, you would probably do this, and all procedures of collective bargaining are made in the way that the unions must create the joint bargaining unit, and then, basing on the rules of democracy, depending on how many members do you have, they will have their respective amounts of votes. If you represent 80% of workers and this bad union represents 10% of workers, then you have 8 votes and you have 1 vote. And you understand that this majority union, even if it is the fake union, which doesn't have the real authority, and the membership is just the imitation, still formally it will represent more, and it may block the formal demands within the collective bargaining, which may be quite problematic. And the only mechanisms which are left for the minority unions in such situation is some political actions, trade union campaigns, information of workers, and then the issue of the level of democracy in this specific country becomes very important. It becomes of crucial importance, because I will show you this on the examples of specific member states. Also, another feature, I will talk a little bit more about the differences between the 5 member states of the Eurasian Union. But first, the similarities. Similarities are based on the similar approach to rather detailed regulation of the employment relations. For example, all grounds for dismissal on employer's initiative, in contrast to German situation, are listed specifically in the labor codes. For example, in Russia, you may be dismissed for what is called pragul, the unexcused absence at work if you are absent for more than 4 hours. It is specifically mentioned in Russian labor code, and in Kazakhstan the same notion in the labor code states that it is more than 3 hours. In Kyrgyzstan it would be 4 hours, etc. And all the grounds are listed specifically, and other regulations are also comparable. So if collective bargaining is weak, statutory regulation is rather detailed, and the amount of rights you have depends very much on specific contents of the labor legislation, and it attracts crucial importance because of this. All countries are not very much aware about the notion of discrimination. The very idea is not very developed. All countries have ratified the conventions regarding the ILO conventions regarding discrimination 100 and 111. All have the definition of discrimination. Some of them have specific notions of violence and harassment at work. One of them, Kyrgyzstan, has already ratified ILO convention regarding violence and harassment at work, and Kazakhstan is considering this. But still very understanding of what discrimination is when we talk about discrimination in the country is very vague. For example, in all post-Soviet countries, I would say to you, I would offer you the example of myself being in Uzbekistan once, and with the ILO mission, I was waiting for my colleague in order to start negotiations with the government officials, and I was sitting in the hotel lobby and listening to the job interview. I couldn't escape it because I was the only one sitting in the lobby beside the table where this interview was happening. And I heard that some senior gentleman came and said, and it was the manager of this hotel, and this manager was saying, well, sorry, we were thinking that you are younger. You are 65, and we were thinking that you are 55 max, and well, you probably don't, well, you are not something which we're serious. And I am saying to myself, well, shut up, you are not here to interfere, it's not in your country. Finally, I couldn't stay silent, and I said, so sorry for interference, but what you are discussing now is the age discrimination. And the lady, there's a representative of the hotel, was very much surprised and said, what are you talking about? This is private business. What do you mean? We are just hiring whom we want. It's a private business. And I explained to her that, well, sorry, but labor code is still applicable to you and you cannot discriminate. She was very surprised. She knocked at my room in half an hour and said to me, well, I gave a thought to this, and we hired him because, well, why not? And the things you were telling are reasonable. This is some kind of illustration that the very notion is not very well understood, and it often requires the explanation. But the reference to discrimination comes in almost every legal claim. I was illegally dismissed, therefore it is discrimination. All breaches of law are considered as some kind of discrimination, which again shows the lack of understanding of what discrimination is. So, Belarus is the most Soviet-style regulated country, and the most, well, Lukashenko's regime is the most oppressive one. And when we talk about this division between the independent and state-controlled trade unions. State-controlled trade unions are in very good position, and most of independent trade unionists are currently in prison. It was different some years ago, but Lukashenko's regime is also worsening in the years, and after his fraudulent election in 2020, when there were mass protests, trade unions were all against this election frauds. Independent trade unions were involved in this, and then there were modification in penal and labor legislation for additional repression against strikers, additional repressions against trade unionists, and currently ILO is, well, I remember myself in 2021, it was the ILO seminar with the independent trade unionists and discussion of the new Belarusian legislation on trade unions. 3 of the participants, major participants of 10 who were participating there, later were in prison, and one of them, the most famous one, Yarashuk, is still in prison, and there is an international campaign for his release, and there is no even information of what is happening with him because Lukashenko's political prisoners are even cut from the information from the outside, and the outside world is cut from the information about them. And if we, I will talk about what is written here. If we go for other countries, I see that I'm taking a little bit too much time, but I will squeeze the migration part probably, and will talk as much as you would like. Russia is surprisingly most social among this. It is not democratic at all, obviously, but also there is this division for alternative and official trade unions. Alternative trade unionists, many of them have emigrated from Russia, but they are not imprisoned. And the labor legislation itself is much more protective in respect of workers compared to most of other countries. Kyrgyzstan is the most chaotic country in terms of labor regulation and labor administration. In this country, for I cannot give you the exact number for the year 2025, but when we were making the research of the situation 5 years ago with colleagues, for 25 years of independence at that moment, there were 17 labor ministers changed one after another. So usually, and it was all about the status. The ministry was renamed, reshaped, became the government agency. And when we came to the Ministry of Labor to talk with some specialists about the situation of with labor regulation, labor inspection, we found 2 student girls who had no idea about legislation at all, were sitting like secretaries without any understanding what is just happening around them. So it's a kind of mess. The labor code is, the previous one was written as kind of copy of Russian earlier labor code, but currently in 2025 they have adopted the new labor code, the worse one, which was made looking more attentively to Kazakhstani model. Kazakhstan labor regulation is a kind of difficult mixture of authoritarian attitude towards the public protests to strikes. It was very much triggered by the revolt of workers, not the rights of workers in 2011 in the city of Eurasian. This is the oil region where the labor conditions are very hard, and the protests became violent and they were suppressed by police, and 17 people died because of this unrest. And after this, the government reaction to the situation was the complete reform of the labor legislation in 2014 and 2014. There was a new law on trade unions, new labor code, new penal code, which established much more severe responsibility for even agitation for illegal strikes, and you cannot know when you are agitating for the strike whether it will be considered illegal or not. And the labor code was completely redrafted in favor of employers. It was made in very neoliberal attitude towards the employment relations, combined with the oppressive attitude to workers, kind of Lee Kuan Yew inspiration to regulation of work, which is very unhealthy, I would say, from sort of not talking about the humanity. And I think one of the reasons for the attempt of revolution in January of 2022 in Kazakhstan, it was the big social unrest in January of 2022, which almost led to the complete change of power, and in fact it has led to the de facto change of power, because most of the time of independence of Kazakhstan, it was headed by President Nazarbayev, and before this unrest in 2022, he officially ceased being the president. He retained the status of Yelbasi, some kind of leader, first president with special status, with status and capital city named after him, etc., but formally not the president, still trying to control the formal president. But after this riot, the formal president, Tokayev, became the actual president. So the power has shifted, and the new president has declared the course for the democratization. It is rather unexpected course after the violent oppression of rights. For example, in Belarus, 2 years earlier, when Lukashenko managed to oppress the riots, it has just made his dictatorship course worse. But here, it was the declaration of policy towards the new Kazakhstan, to the so-called hearing government, to democratization, and the new president has offered the changes in constitution where the president cannot be for more than once without the possibility for election ever, which is rather surprising. Let's see what will happen after the expiration of his term. And it didn't, I will terminate on this, just to give you the illustration of what is happening in the region. It didn't change yet to the changes in the oppressive regulation of collective labor law and liberal regulation of individual labor law. But Kazakhstan, after this reform, the earlier reform of 2014 and 15, became one of the most criticized countries by the ILO. Here you see the different names of the ILO controlling bodies or procedures, from the mildest to the most severe, I would say. And first of them is Committee of Experts on Application of Conventions and Recommendations. This committee, controlling body, may issue two types of documents. Direct requests in some technical cases when it requires some information. They are not officially published documents, just a kind of communication between the governments, or the observations when the issue is more serious. And you may see that in the last 10 years, all countries have received some number, and some of them pretty significant number of these observations. Irrespective of the level of the biggest number, you may see Kazakhstan, the second biggest is Russia, the third is Armenia, which is also rather chaotic and comparable to Kyrgyzstan to a certain extent when we talk about the labor regulation. This is the one of the high procedures. This is Committee on Application of Standards, which considers 25 most resonant cases of in compliance with international labor standards in the world annually. Out of 187 member states, it considers 25 cases annually. So if the country is under discussion in this committee, then it is already a serious problems. You see that Russia has never been discussed for the last 10 years in this committee. Armenia and Kyrgyzstan were discussed 3 times, and most of them is disorganization. They were not reporting regarding their obligation to report about the legislation. Kazakhstan and Belarus were discussed 7 times out of 10 years. So it's almost every year they were under discussion among 25 most resonant cases. Some of the countries, again, except for Armenia and Kyrgyzstan, were under the discussion of specific Committee on Freedom of Association because of serious failures with freedom of association. And one of these countries, Belarus, was under the most significant, the hardest procedures, Commission of Inquiry, which is the ad hoc commission which considers the most problematic issues, and Article 33 of the Constitution of the ILO. Article 33 of the Constitution provides that if the member state of the International Labour Organization is in the situation of very long-term and very grave in compliance with international labor standards, then the International Labour Conference, representing all the countries, may address to the governments, to the member states, in order to take some action against the state. So ILO cannot call for, cannot put some sanctions, but it may address to the states to call such sanctions. In the history of the ILO, this is 105 years, it was established in 1919 after the First World War, there were 2 cases of application of this article. One in the year 2000 regarding Myanmar, because military junta of Myanmar was exploiting the forced labor for decades and was ignoring everything. Second case is Belarus and repressions against trade unions. Coming back to Kazakhstan, Kazakhstan was not under this article, but if you see here, it is under the comparable amount of criticism, both by ILO. There is a special European Parliament resolution regarding human rights in Kazakhstan, which is dealing mainly trade union rights in Kazakhstan. So it is specified on this. There's a application from the biggest United States trade union, AFL-CIO, to the government of the United States to take Kazakhstan out of the general system of preferences in trade because of the violation of trade union rights. And it is named, it was named for a number of years by the International Trade Unions Confederation, the biggest world trade union confederation, among 10 countries with the worst situation with workers' rights. It was the huge amount of criticism versus Kazakhstan. And after this, Kazakhstan, when this policy to democratization started, started discussing with the ILO the possibility to democratize something in collective labor law. And we were assigned to make the recommendation what to do with collective bargaining, collective labor disputes, and the right to strike. We made a number of recommendations for the ILO, and the ILO has presented it to government. After this, our university has created the joint working group with the Senate, the upper chamber of the parliament of Kazakhstan, in order to create this, to form this recommendation in the form of the draft law. And the draft law was presented to working group. It was discussed for a year. And currently, some of the proposals which has passed the year discussion on making the collective labor disputes and strike possible have passed this tripartite working group. They have passed the government, and government has cut like 2/3 of these recommendations and said that most of these recommendations we are not supporting, but still about 1/3 of them we are supporting, and it is offered for the autumn session of the lower chamber of parliament, Majlis, for this year. So there is some hope of progress in this issue. Let's see what will. And I'm finishing on this because I understand that I abused your time. Still, if you would like to discuss, I'm here. I'm sorry for taking too much time. So. Thank you. So it's up to you whether to.
Thank you very much. Yes, we are a bit late. Other questions, please? Points for discussion. Please go ahead.
I have several questions, so I'll make the start. My first question is, you said there is like freedom for workers between the EU.
Yeah.
Well, what about social security? Let's give you something from the European Union or the European Community. Like the third legal regulation in 1959 when it was created was about social security, because they have seen that, well, if you have freedom of workers, it has no feasibility, no practical feasibility if you don't think like pensions and
you lose your pension
insurance and something with if there's some provision for that in the EU.
Unfortunately, it is dependent on bilateral agreements. For you to understand how the system is complicated, I cannot answer you definitely whether I am retaining my own personal pension rights. I have received some pension rights which I'm not entitled for the pension until I reach 65 in Russia, but I cannot say you for sure now whether my 3 years of work in Kazakhstan add to my pension contribution, because it is dependent. I need to make a special research on this in order to understand whether there is a bilateral agreement between Russia and Kazakhstan on the issue, and it is not solved uniformly on the level of Eurasian Economic Union, unfortunately.
Well, I think that hampers freedom of workers, because like you don't want to work for a longer time if you don't want to add to your pension.
You are looking by very European eyes on the issue, because you consider that pension is something realistic and something which may support you when you are old. This is something with which you can survive. Unfortunately, in the post-Soviet countries, the level of pensions is so low that, according to the ILO Convention 102, the pensions should substitute at least 40% of the salary which you were receiving in the year when you were terminating your work. Presuming that it is the highest wage you normally receive, closer to. This 40% threshold is not met in any of the post-Soviet countries, and usually it is pretty far from this. And people usually don't rely on the state pension because they don't trust the state. Because when it is state controlled, and they have the Soviet experience, because there was a hyperinflation in all post-Soviet countries in the 1990s, and the pensioners, which were entitled to quite survivable pensions in Soviet times, instantly, when can you imagine that you are 80 at a certain moment and you're receiving some pension which is pretty survivable, and now it's nothing. You cannot buy medicines or food for this, and you cannot work anymore. And currently the situation is not that dramatic, but still there is a big level of distrust. And usually when you're a kind of middle-class worker, and you think about your pension in 20 or 30 years perspective, you know that the state you're living in and each of these post-Soviet states is very unstable, and you just don't rely on this. You think about other means to survive. It's better to have the apartment to rent out or something else. If you don't have it, well, sorry for you. This is kind of practical explanation of this.
Further questions? Otherwise, you two, of course, have the possibility to discuss bilaterally. Further questions?
I'm sorry that I have taken...
No, don't worry, that's fine. No, thank you very much. This was very interesting. It was, you covered, of course, a lot in terms of the countries, but it was good to get a comparative perspective and also to show how challenging labor law, social security law are in countries of transition from a planned to a market economy, and that it takes time to reach certain standards which maybe the ILO or the European Union think they are adequate. Yeah. It's a good example, I think, with regard to transition, and that is, of course, what we do as research here. Thank you very much.
Thank you.
Thank you for the audience.
Thank you for inviting.
And we keep this conversation going on for future meetings. Thank you very much.
I will be happy. Thank you.